Within the last couple of weeks, I was reminded of a very, very important point that we preach here consistently at Dubo Law, but was afforded an opportunity to actually practice what we preach, which is that our cases belong to our clients, not to us as lawyers. We had a case that we've been handling for the last 3+ years now, where a client of mine was a passenger on an MTA bus. The bus stopped to let him off, and my client wasn't aware that when the bus let him off, it was not at the curb, it was actually a lane away from the curb. He stepped off, and there was another vehicle traveling in that right hand lane, which unfortunately hit my client. And as a result, he suffered pretty severe injuries. MTA denied responsibility for the accident. They actually tried to blame my client. And so as a result of that, we filed a lawsuit and spent the next few years going through litigation. Um, we took a lot of depositions, we exchanged documents, and as the case continued to develop, it became clear to me that this was a stronger case than maybe even we originally thought. And we were getting within a couple of weeks of going to trial, which we were very excited about here at Dubo Law because this was a great case with excellent facts, and it was really shaping up to present very well at trial and get what would be an exceptionally favorable outcome for our client. And coupled with the fact that as we went through, MTA consistently had denied responsibility for what they had done, so there were no settlement offers at all. This was just a case that was going to have to go to trial. Less than 2 weeks from trial, as we were continuing to get geared up and again being very excited about the prospect of going to trial, the attorney for MTA contacted me and presumably having taken a closer look at the case and recognizing that there were some concerns, she called with a settlement offer. It was an offer that I considered to be less than fair value for the case, but obviously I consulted with my client, and it became clear to me during that conversation that my client had no real interest in going to trial, and that as long as there was a even remotely reasonable settlement offer on the table, it was his strong preference to not take any risk of going to trial or have the stress, which for him was something he would have preferred to avoid. And again, my instructions from him were just go ahead and get the case settled. After some negotiating back and forth with the MCA attorney, we reached an amount that my client decided was good enough for him to want to settle the case. Now, of importance here was the fact that I continue to believe, and as I sit here now, believe that we would have done better at trial than the settlement offer we got from MTA, which my client decided to accept. But again, going back to my original point, it was a reminder to me that as lawyers, these cases do not belong to us. This case belonged to him, and it was his decision as to whether or not he wanted to go to trial or wanted to settle. As long as I gave him all the information he needed to make an informed decision, it was his decision to make, and he made it. And as long as he's happy, and he was thrilled with the outcome, that's all that matters in the end. And so, again, just a real life example and reminder of how, as lawyers, our job is to work these cases up the best we can, to prepare them to get the best outcome at trial. But at the end of the day, if they settle, as long as the client's happy with the settlement and the client has been fully advised and informed, that's all that matters.